Hello and welcome to Legally Gamer, a YouTube series where we discuss legal issues that affect the video game industry. In today's episode, we're going to be discussing...
We had a deal with you on the comics, remember, for likeness rights? And as we're not only the artistic basis, but also obviously the character basis for your intellectual property, Bluntman and Chronic, when said property was optioned by Miramax Films, you were legally obliged to secure our permission to transfer the concept to another medium. As you failed to do that, Banky, you are in breach of the original contract. Ergo, you find yourself in a very actionable position.
Yeah. That's right, we're discussing likeness rights. So-called likeness rights are actually considered part of an individual's right of publicity. The right of publicity recognizes that an individual has a right to control others' use of his or her identity for commercial purposes. The Supreme Court of California described the right this way. Often, considerable money, time, and energy are needed to develop one's prominence in a particular field. Years of labor may be required before one's skill, reputation, notoriety, or virtues are sufficiently developed to permit an economic return through some medium of commercial promotion. For some, the investment may eventually create considerable commercial value in one's identity. The elements of a right of publicity claim, at least under California law, are 1. The defendant has made use of the plaintiff's identity. 2. The use of plaintiff's identity is for the defendant's advantage, commercially or otherwise. 3. A lack of consent from the plaintiff. And 4. An injury to the plaintiff as a result of the use. And that brings us to the case before us today. And since it's Super Bowl weekend, why not discuss football? In 2005, Sam Keller was the starting quarterback at Arizona State before he transferred to the University of Nebraska for the 2007 season. Keller, like thousands of his fellow student athletes, was recreated virtually for Electronic Arts' annual NCAA Football video game. EA goes to great lengths to ensure the authenticity of its sports games, from sending questionnaires to athletic trainers to assure accurate height, weight, and build for players, to ensuring realistic stadiums, cheerleaders, and sounds. EA does omit the player's name on the back of their jerseys and creates a new hometown for each player, but everything else is basically how it is in real life. In May of 2009, Keller filed a class action lawsuit against Electronic Arts, claiming that EA appropriated his likeness in violation of his right of publicity. EA moved to dismiss the lawsuit under California's anti-SLAPP statute, which is meant to discourage suits that are brought to deter individuals from exercising their political or legal rights or punish them for doing so, such as EA's First Amendment rights. EA's motion to dismiss ultimately hinged upon whether EA could prevail as a matter of law on its defenses. EA raised 4 defenses in response to Keller's right of publicity claim. 1. The game was sufficiently transformative to trigger First Amendment protections. 2. Protection under the Rogers test. 3. That the work was sufficiently in the public interest to receive protection. And 4. That the work fell under the public affairs exception. The Ninth Circuit, who was reviewing the case on appeal, quickly rejected the last 2 defenses because they only apply to the reporting of public information, such as newspapers and newscasts. The court also rejected the Rogers test, as it does not implicate the same interests as the right of publicity. As a result, this video is going to focus on EA's argument that its games are sufficiently transformative to guarantee them First Amendment protections. The transformative use defense to a right of publicity claim was first articulated in 2001 by the California Supreme Court in a case regarding the use of the Three Stooges likeness on a t-shirt. The transformative use defense is a test meant to balance the parties' interests and ensure that the work in question adds significant creative elements so as to be transformed into something more than a mere celebrity likeness or imitation. The California Supreme Court recognized the defense because when a work contains significant transformative elements, it is not only worthy of First Amendment protection, but is also less likely to interfere with the economic interests protected by the right of publicity. The transformative use defense is not a wholesale importation of the fair use defense from copyright law. Instead, the defense constitutes a consideration of 5 factors. 1. Whether the depiction or imitation of the celebrity is the very sum and substance of the work in question. 2. Whether the work in question is primarily the defendant's own expression and is something other than the likeness of the celebrity. 3. Whether the creative elements of the work predominate over the literal and imitative elements. 4. Whether the marketability and economic value of the work is derived primarily from the fame of the celebrity depicted. And 5. Whether the artist's skill and talent is manifestly subordinated to the goal of creating a portrait of the celebrity so as to commercially exploit his or her fame. In considering these elements, the Ninth Circuit found that EA's use of student-athletes' likenesses was not entitled to First Amendment protection as a matter of law. Important to the court was the extent EA went to ensure athletes were realistically represented. As the Ninth Circuit said, EA elected to use avatars that mimic real college football players for a reason. If EA did not think there was value in having an avatar designed to mimic each individual player, it would not go to the lengths it does to achieve realism in this regard. Additionally, it seemed a California Court of Appeals case had recently spoken on a substantially similar situation in the video game industry, No Doubt versus Activision Publishing. In the No Doubt case, the band had sued Activision for exceeding its license in the game Band Hero by allowing the player to use No Doubt's likeness during song performances that were not by No Doubt. The California Court of Appeals found that Activision was not entitled to First Amendment protection and placed great weight on the fact that the depiction of No Doubt was used in the same activity by which the band achieved and maintains its fame. Turning back to EA's use of student-athlete likenesses, the Ninth Circuit noted how, just as in the No Doubt case, student-athletes were also depicted in the same role they portrayed in real life. Specifically addressing Sam Keller's appearance in the NCAA football games, the Ninth Circuit explained that Keller is represented as what he was, the starting quarterback for Arizona State and Nebraska, and the game's setting is identical to where the public found Keller during his collegiate career, on the football field. The Ninth Circuit also rejected EA's argument that its games were transformative as a whole because they allowed players to alter the characteristics of student-athletes. Specifically, the Ninth Circuit pointed out that the ability to modify the characteristics counted for little when the appeal of the game lied in the user's ability to play as or alongside their preferred players or teams. In fact, many users use the ability to customize players to simply make them even more realistic by uploading entire rosters of player names to further cement the immersion that they are playing with or as real college athletes. As a result, and based upon consideration of all these facts, the Ninth Circuit held that EA's use of student-athletes' likenesses was not transformative and therefore not protected by the First Amendment. With the denial of EA's motion to dismiss affirmed, what happened next? Well, that dominated the headlines.
$40 million. That's how much Electronic Arts and Collegiate Licensing have agreed to pay former athletes for the use of their likeness in video games. The settlement agreed to on Friday brings one aspect of the
NCAA updates and news. You will know athletes are finally starting to receive their checks from EA as part of the settlement reached in the Ed O'Bannon lawsuit. EA settled with the players and now the money has been paid out.
College athletes have settled a lawsuit with Electronic Arts after the athletes weren't compensated for appearing in EA's NCAA game series.
Thanks for watching. This is the first episode of my new Legally Gamer series. If you have any suggestions, whether how to improve the series or topics to discuss, let me know in the comments below. Also, feel free to ask me any questions you have regarding this case. If you enjoyed the show, feel free to give the video a like and click that subscribe button so you can see when I upload new videos. Thanks for watching.